Understanding the various forms of discrimination prohibited under the Arizona Civil Rights Act, ARS Section 41-149, 1 through Section 41-149, 1.37, is essential for every real estate professional. This section builds upon the principles of fair housing by explaining what constitutes discriminatory behavior and how such actions can occur in real estate transactions. The Arizona Civil Rights Act mirrors the Federal Fair Housing Act, prohibiting any practice that denies or limits housing opportunities to individuals based on race, color, religion, sex, disability, familial status, or national origin. The Act applies to all aspects of housing, including the sale, rental, financing, and advertising of dwellings, and it protects both buyers and renters from unfair treatment. ARS Section 41-149, 1.14 clearly states that it is unlawful to refuse to sell, rent, or negotiate for housing, or otherwise make housing unavailable to any person because of their membership in a protected class. Discrimination may be overt, such as outright refusal to deal with a certain group, or subtle, involving practices that have the effect of excluding or discouraging individuals from housing opportunities. Real estate professionals must recognize these forms of discrimination to avoid violations that can lead to serious legal and disciplinary consequences. One of the most common forms of housing discrimination is refusal to sell or rent. This occurs when a property owner, landlord, or agent denies housing to an individual because of a protected characteristic. For example, refusing to rent to a family with young children because the landlord prefers adults. Only tenants violates the prohibition against familial status discrimination. Similarly, denying a home sale to a qualified buyer based on their national origin or religion is a direct violation of fair housing law. Another prohibited practice is steering, which happens when a real estate licensee guides clients toward or away from certain neighborhoods based on their race, ethnicity, or other protected trait. Even well-intentioned comments such as, "You may feel more comfortable in that neighborhood," can constitute steering and are illegal under both federal and state law. Steering denies clients the right to make their own housing choices and perpetuates segregation. The Arizona Attorney General's Office treats such conduct as a serious violation of the Arizona Civil Rights Act, and licensees found guilty may also face disciplinary action under ARS Section 322153A3 for dishonest or untrustworthy conduct. Blockbusting, also known as panic selling, is another form of discrimination that targets homeowners rather than buyers. It occurs when a person or agent attempts to induce property owners to sell their homes by suggesting that people of another race, religion, or background are moving into the neighborhood, implying that property values will decline. This manipulative tactic is prohibited under ARS Section 41-149, 1.15b. For example, if an agent tells a homeowner, "You should sell now before the neighborhood changes," that statement violates fair housing laws. Blockbusting not only fosters racial fear and division, but also undermines community stability and trust. Redlining is a discriminatory practice typically associated with lenders or insurance companies. It involves refusing to provide loans, insurance, or financial services to individuals in certain neighborhoods based on the racial or ethnic composition of that area rather than legitimate financial criteria. While primarily a violation of federal law under the Equal Credit Opportunity Act, ECOA, and Fair Housing Act, redlining also violates the public policy embodied in Arizona's Civil Rights Act, which promotes equal access to housing and credit. For instance, if a lender systematically denies mortgage applications from applicants living in predominantly minority neighborhoods, that lender could face both civil and criminal penalties. Discrimination may also occur through advertising, where language, images, or implications suggest a preference, limitation, or exclusion. ARS Section 41-149-1.15A3 prohibits any advertisement that indicates a preference based on a protected class. Phrases like ideal for single professionals, Christian community, or no children allowed are examples of discriminatory advertising that violate fair housing laws. Real estate professionals must ensure that all marketing materials, MLS descriptions, and social media posts use inclusive and neutral language. Another critical protection under the Arizona Civil Rights Act is for individuals with disabilities. ARS Section 41-149-1.19 mandates that housing providers must make reasonable accommodations and reasonable modifications for persons with disabilities. Reasonable accommodation refers to policy adjustments, such as allowing a service animal in a no-pets property. Reasonable modification refers to physical changes to the property, such as installing ramps or grab bars. Refusing to allow these changes or failing to provide accessibility features when requested constitutes unlawful discrimination. Familial status discrimination occurs when individuals are treated unfairly because they have children under the age of 18 living with them, or because a woman is pregnant. For example, a landlord who refuses to rent an upstairs apartment to a family with children because of noise concerns is engaging in discrimination. The only exceptions to this rule apply to qualified housing for older persons, such as senior living communities that meet the specific criteria outlined in ARS Section 41-149-1.04. Finally, harassment or retaliation is also prohibited under the Arizona Civil Rights Act. It is illegal for any person to intimidate, threaten, or retaliate against an individual for asserting their fair housing rights or assisting others in exercising those rights. For instance, a landlord cannot evict or harass a tenant for filing a discrimination complaint with the Attorney General's office. Such conduct violates ARS Section 41-149-1.32, and offenders may face civil penalties and damages. For real estate professionals, understanding and avoiding all these forms of discrimination is not only a legal responsibility, but also an ethical obligation. Under Commissioner's Rule R4-28-1101B, licensees must act fairly, honestly, and without bias toward all clients and customers. Ignorance of fair housing law is never an acceptable defense. Review Summary. The Arizona Civil Rights Act, ARS, Section 41-1491 AECQ, prohibits all forms of housing discrimination based on race, color, religion, sex, disability, familial status, or national origin. Common violations include refusal to sell or rent, steering, blockbusting, redlining, discriminatory advertising, and refusal to provide reasonable accommodations or modifications for persons with disabilities. Licensees must ensure that all actions, statements, and advertisements reflect fairness and neutrality. The law also protects individuals from harassment or retaliation for asserting their fair housing rights. Compliance with these principles is both a legal requirement and a professional standard of practice in Arizona real estate. Discussion. What are some examples of discriminatory conduct prohibited under the Arizona Civil Rights Act? Answer. Refusing to sell or rent based on protected class status, steering clients toward or away from certain areas, blockbusting, redlining, and using discriminatory advertising language. Why is steering considered a violation of fair housing law? Answer. Because it limits a person's housing choices based on protected characteristics and promotes segregation, which violates the right to equal housing opportunity. How does the Arizona Civil Rights Act protect individuals with disabilities? Answer. By requiring housing providers to allow reasonable accommodations and modifications to ensure equal access to housing. Closing remarks. The prohibition of discrimination under the Arizona Civil Rights Act represents a vital commitment to equality and integrity in housing. Real estate professionals must lead with fairness, respect, and awareness to uphold the law and the ethical standards of their profession. Understanding the many forms of discrimination, whether overt or subtle, allows agents to serve all clients with honesty and impartiality. Compliance with fair housing law is not merely about avoiding penalties. It is about ensuring that every individual has the freedom and dignity to live where they choose. 2.3-2- Discrimination prohibited under the Arizona Civil Rights Act.